Good afternoon, everyone. Thank you so much for joining us today. My name is Nafisa Chaudhary. I am a partner in the Labor and Employment Group here in Toronto. I'm joined today by my partner, Terry Triber, who is in our Calgary office, and she'll be presenting on some interesting topics we're hoping today for you. So our presentation, we zeroed in on various termination of employment-related topics. These are on particular issues that we find come up fairly frequently for our clients, and also an area where there's always constant evolving changes in the law. So we are hoping that we have an interesting, interactive presentation for you today that gives you an update on where things are going on three particular topics. The first is with respect to termination clauses in employment contracts. The second is on just cause for termination. And the third will be with respect to the enforceability of confidentiality provisions in contracts. Before I hand it over to Terry, there is a bit of housekeeping that I've been asked to speak to. This is particularly for those of us who are joining the conference for the first time. In particular, you've been placed on mute due to the high number of participants. Secondly, there is a Q&A chat that is open that you'll find in the top right corner of the screen. While the questions they'll be made available to us at the end of the conference, and we will respond to them after the conference is done. But don't hesitate. If you have any questions, please do submit them. In case you need technical support, please find the help button below the video window right next to the return to agenda button. And finally, perhaps quite importantly, our standard caveat, which is that this presentation is for informational purposes only and is not legal advice. So please do contact us if you have any questions, any advice that you need on a matter, and we of course are always happy to assist. So without any further ado, I'm going to hand it over to Terry to talk to us about termination clauses.
Thanks, Nafisa. Okay, so termination clauses. Next slide, please. So first, I'm going to talk about reasonable notice of termination. So many of you, I'm sure, know this, but just as a refresher, every employment relationship is subject to an implied term that the employee can be terminated on a without cause basis, as long as the employee is given reasonable advance notice or pay in lieu of such notice of the termination. Determining how much notice to give someone when we're talking about common law notice is more of an art than a science. Sometimes you hear people talk about things like a 1 month per year of service rule of thumb. That's not accurate. But typically you are talking about months as opposed to weeks, like we see in the minimum standards legislation. When determining what someone's common law notice entitlement is, courts will look at four main factors in particular, those being the character of employment. So more senior level positions tend to get longer notice periods. Length of service, same thing. The longer you've been employed, the longer the notice period tends to be. Age, again, employees nearing retirement age tend to get longer notice periods, and the availability of similar employment having regard to the experience, training, and qualifications of the employee. This is not an exhaustive list, though. A contextual analysis will always be required. So certain other factors can impact the notice period, things like if the employee was induced over to come to work for you from another secure employment situation prior, if the economy is particularly bad, although that one can go both ways. But just a note that it's not, those four factors aren't closed. Sometimes the courts will look at other factors as well. In terms of common law notice, the rough upper limit is said to be 24 months in most cases, but longer notice periods have been awarded in some cases, including for the first time in Alberta fairly recently. Next slide, please. So termination clauses 101, the obligation for employers to provide reasonable notice at common law, which I just talked about on the last slide, can be displaced if the parties enter into an express written termination clause in an employment agreement. In that situation, the employer and the employee agree to what the employee's entitlements will be if their employment is terminated without cause. They must be provided with termination entitlements that are at least equal to or greater than what the employment standards minimum legislation says that they must get as a minimum requirement, but it can be lower than those common law notice entitlements that I talked about on the last slide. So the benefits of this include capping that common law notice liability, right? Instead of a situation where an employee's common law notice could be quite significant, at the outset of the employment, you can work with the employee to try and negotiate something that both sides feel is more reasonable. It helps to set mutual expectations and creates certainty. So you're not having to spend so much time litigating and fighting about what the common law notice period will be. And of course, that's assuming everything goes smoothly, which we know it always doesn't. Next slide, please. So termination clauses can be finicky. They're often subject to scrutiny by the courts. There's a whole number of ways that they can be attacked by employees. But the main points are that it's important that they're compliant with minimum standards legislation. Like I said, if you drop below the minimum standards legislation in terms of like providing less notice than what is required, that can pose issues. There's some other issues that can arise, which Nafisa will talk about briefly in the next few slides as well. The clauses must be clear and unambiguous. Generally speaking, any problems will be decided in the employee's favor. So we'll often see employees try to argue, that clause, could be interpreted in two ways. And so court, you should grant me common law notice instead. It's important that the clause is express about the intention of the parties to displace the common law. When I'm drafting, I like to specifically say, like, the parties agree that this person will not get common law notice and that, the contractual entitlement is like what will govern. And another one that we commonly see being a bit of a pitfall is fresh consideration. So it's important that like any contract, employees that are signing off on a contract containing a termination provision get fresh consideration for signing. That means that if it's a new employee, they've signed before they've actually started working. And if it's an existing employee and you're asking them to sign a new agreement, they're getting something new of value in exchange for signing. That can't just typically be continued employment. Usually what we're talking about there is something like a signing bonus, pay increase, more vacation time, that kind of thing. Next slide, please. Okay, so now I'll turn it over to Nafisa to talk about a few of the latest updates in this area.
Thanks so much, Terry. So as Terry mentioned, this area is finicky when you talk about interpretation and proper application of termination provisions. And anytime you're dealing with a finicky area of law, that means the court's intervention is pretty common. And the court's intervening, of course, results in constant updates to the case law. So you always have to be mindful about what's happening in the jurisprudence when it comes to enforcement of termination clauses. Something that may have been good law, even a month ago, sometimes is no longer good law today. So here are some important updates that have happened recently. Many of these you may be aware of, but again, this area is changing constantly. So the first that I want to zero in on is a case called Waxdale versus Swegan. So this case is from 2020, so it's a few years old now. It was sort of the first case that we had in a while that introduced a bit of a sea change in Ontario anyway. And this is an Ontario-specific issue. I just want to make that clear for this particular case. Ontario has just cause provisions in our Employment Standards Act, which are unique. There's certain language in Ontario's statute which make it such that a termination provision, if the with cause provision is drafted in a certain way, then it may be a breach of, interpreted to be a breach of the Employment Standards Act. So that's precisely what happened in this Waxdale case. There was two, as in many employment contracts, there's a for cause or with cause termination provision, and then there was a without cause termination provision. The employee was terminated. They challenged the termination provisions in the contract and said, no, I'm entitled to more. And the court took a look and said, look, the without cause provision was enforceable. They were satisfied that that was enforceable. But they took a look at the with cause provision and felt that because the with cause provision was unenforceable, they felt the language did not comply with our Employment Standards Act, the ESA, and so that provision was invalidated. And the employer there argued, hey, wait, well, even if the with cause provision is unenforceable, it doesn't matter because this person was terminated without cause. But the court said it doesn't matter. These two provisions have to be interpreted and applied in tandem because termination provisions is kind of part of a whole. And because the for cause provision or the with cause provision was unenforceable, the entirety of the provision was struck down. So you have to be careful when you're preparing your contracts. Look at both the for cause provision as well as the without cause provision because they both have to be enforceable. Next slide, please. The second latest update, this one is far more recent. It has caused, again, a bit of a sea change. This is the Dufo case that came out in 2024. So what happened in Dufo was there was a termination provision that was at issue. And the for cause provision had, and the without cause provision had a language in there, certain language in there that said that the employee can be terminated at any time and at the employer's sole discretion. So those are the sort of the critical words that were in that provision. Otherwise, the provision seemed to suggest that the employer intended to comply with the ESA or the employee would get their minimum entitlements. The employee challenged that provision and said, well, look, the language of at any time and sole discretion is a violation of the statute because it suggests that the employer can terminate me even when it's unlawful for the employer to do so, such as if I'm coming back from a job protected leave or in under certain Occupational Health and Safety Act situations. And the court accepted that argument from the employee and invalidated the provision. So that was appealed up to the Ontario Court of Appeal. And at the Ontario Court of Appeal level, the court took a look at the provision, the anytime language and the sole discretion, and said, look, we don't really need to get into determining whether that part was rightly decided because the for cause provision or with cause provision was clearly unenforceable. So because that was unenforceable, the entire provision fell, and the court declined to make an express finding on whether that new line of decision about any time and at sole discretion, whether that was acceptable. And the reason why this is important is because that language of at any time is very commonly used in termination provisions in employment templates. In fact, many of you who are watching this today, if you go back and look at your employment templates, you may very well see that language sitting in your templates. And if that's the case, then definitely you'll want to update that and consider the case law because it does absolutely apply to your cases. Now, next slide, please. So a moment ago, I mentioned that the Ontario Court of Appeal said, you know what, they didn't want to get into an express finding of whether the at any time and at sole discretion language was acceptable because they didn't need to. So that then has resulted in a number of other cases going ahead at the Superior Court level, so one court below the Ontario Court of Appeal. And these are all cases where there are termination provisions being challenged, where that at any time language is there. And the courts have actually diverged. They've gone two different ways. There have been a few cases where the courts found that the language of at any time, just like in Dufo, was sufficient to render the provision unenforceable. And we've got a case there, Baker versus Van Dolder's home team, 2025 decision. That in that case, the court applied Dufo and found that at any time was good enough to invalidate the provision. And then there's been a few other cases where the courts felt that, no, you know what, I'm not going to apply Dufo. And there's various reasons why the court went that way. In the interest of time, I'm not going to get into them. But two cases where the court did not apply Dufo was in Jones versus Strides, Toronto, and the other is Lee versus Wayfair Canada, both recent 2025 decisions. So the main point is that there is a divergence in case law here. It may be safest just to take out that language so that you're not giving someone a departing employee an unnecessary argument to try and invalidate the provision. And this is an evolving area. So the Van Dolder decision, I believe, is under appeal. So we're awaiting that decision. Next slide.
Okay, so back to me for some key takeaways. Important to remember that many of these issues when it comes to enforceability of termination provisions can be jurisdiction specific. As Nafisa said, for example, in the Waxdale decision, that flowed from legislation that's specific to Ontario, that definition of just cause. Other jurisdictions have different statutory language, and so those cases won't always apply in other jurisdictions. Again, it's important that you're making sure that your agreements are compliant in the jurisdiction that you are working in and have employees in. For example, in Alberta, we don't have that language, and so Waxdale has not made its way here or been applied. When it comes to Dufault, it's a little bit more gray. The Dufault is an Ontario decision, and it hasn't been applied in Alberta. Yet there's been no cases that have considered it one way or the other. Certainly, though, we are seeing employee side counsel, in their demand letters saying your clause says at any time that is been found to be unenforceable. Of course, we respond back and say, no, that's Ontario law. It's not Alberta law. And in any event, the courts in Ontario have gone back and forth on this. But again, can be a good practice to just try and make those changes as the cases come out, just to try and avoid getting into these issues altogether, like Nafisa said. I just want to touch on one recent employer-friendly case from Alberta, just as a bit of a good news story following some of the doom and gloom. So a case in Singh and Clark Builders, 2025 Alberta King's Bench case. In that case, there was a clause that said that the employer could terminate on 90 days notice. The employment agreement was signed when the employee was in a VP role. The intention was always for him to move into this COO role in the future. The employee sued and argued that the clause was ambiguous on the basis that it should be interpreted to mean that he was entitled to at least 90 days notice. And he also argued what's called changed substratum, meaning, I wasn't in the same role when I joined as I am now, and things are so different that agreement shouldn't confine me. He also argued that because the employer initially alleged just cause to terminate, which the employer later backed away from, but he alleged that repudiated the agreement, and the employer shouldn't be able to rely on the termination provision as a result. The court disagreed with all of that. In that case, they said, no, you're a sophisticated employee. You negotiated the terms of this clause. There was back and forth on it. The change substratum wasn't accepted because the intention was always for him to move into that CE role even at the outset. And the just cause piece was found to not repudiate the agreement because the just cause allegation was made in good faith. So just wanted to point that out, and just a note that, again, the law in this area is always evolving. It's something we are always staying up on and seeing what we can do to, improve employment agreements, make them as strong as possible, and encourage you to do so as well. Employers should regularly conduct reviews of employment agreements so that we can make sure that they're always compliant with whatever the newest law is. Okay, so next slide, please. The next part of our presentation that I'm going to talk about is just cause terminations. So you can move to the next slide, please. So what is just cause for termination? That is a situation where the employee is terminated, they're not provided with any notice or pay in lieu of notice, and the employer has a burden of demonstrating that the employee has engaged in misconduct that's sufficient enough to cause a complete breakdown in the employment relationship. The misconduct must be so serious that it violates an essential condition of the employment contract, breaches the faith or trust inherent in the working relationship, or is fundamentally or directly inconsistent with the employee's obligation to the employer. Next slide, please. This is always going to be a contextual analysis. We're always going to be looking at these things on a case-by-case basis. So courts will look at factors such as the nature and extent of the misconduct. Is this a one-off, or is it a pattern of behavior that the employee has been warned for previously? They'll look at how serious the actual misconduct is. Like a CEO who's stealing from the company is going to be treated differently from, a junior level employee who takes some pencils home. They'll look at the circumstances of both the employer and the employee. So again, things like the nature of the industry, the degree of trust reposed in the employee, how long the employee's been with the company. Do they have a good past record? Do they have a bad past record? Why did this happen? Did the employee take responsibility? Those kinds of things. And always need to consider whether termination is a proportionate response to the employee's actions. Just cause dismissal is considered the capital punishment of employment law, and courts may find that there's no just cause if a lesser sanction would have sufficed to correct the behavior. So typically, a pattern of misconduct and progressive discipline with clear warnings about the consequences that will flow if an employee doesn't improve will be required. But that being said, just cause is possible for single incidents. They just must be very serious and severe. And it really is a high bar for employers to prove. I feel like most of us receive calls all the time saying, like, this must be just cause, like the employee has done this really bad thing. And unfortunately, it's really tough to get there. And is something that, we're always, staying up to date on the law. And it just seems like it's getting harder and harder to prove as the cases come out. But on that note, want to talk about a couple of cases and see what you all think about it. So if we move to the next slide, we're going to play a game that we like to call cause or no cause. And so we'll ask you to use the poll to decide whether you think that there is just cause in this case or not. And then I'll reveal the results and talk about whether there was or was not just cause in the actual case. So the first case is Jericho Tennis Club and Unite Here, an arbitration decision from Ontario 2025. In that case, the employee was a maintenance worker who had worked for the tennis club for 8 years. It says on the slide that he had no prior disciplinary record. He actually did have a 5-day suspension, but the arbitrator found that it wasn't necessary for the arbitrator to consider that when making the decision. So for the purpose of this, we'll just say he had no prior disciplinary record. The employee was found sleeping under blankets in the laundry room during work hours. He initially denied sleeping, saying that he was just joking, but his explanation changed over time. The union argued he was merely taking a break outside the designated break area and denied any dishonesty. And the employer argued that sleeping on the job was bad. The employee's dishonesty during the investigation and the hearing undermined the trust in the employment relationship. So the poll's there. Let me know what you think, cause or no cause. You've said no cause. And the answer is that there was cause. So if we can move to the next slide. The employee was dishonest both during the investigation and the hearing, and the arbitrator preferred the employer's evidence over the employee's, noting various contradictions in the story of the employee and his exaggerated claims that everyone was sleeping at work. And although, like I said, the employee had a prior suspension, the arbitrator held that the employee's dishonesty in this case alone was sufficient to irreparably damage the employment relationship. Okay, so next case. This one is on surreptitious recording. The case is Shaligan and Mercer Selgar Limited Partnership. It's a BC Court of Appeal case from 2023. In this case, the employee was a senior financial analyst, 10 years of service. He was a CPA, and he had access to sensitive financial and business information. He was originally terminated without cause, but later at the hearing, actually, it was revealed that over several years, he had secretly recorded training sessions and more than 100 meetings and conversations with supervisors, HR, and colleagues. There was no evidence that the recordings were shared with anyone else. And the employee claimed that the recordings were to protect his rights in case of discrimination or bullying and document workplace issues, and the employer disputed that. So what do you think, cause or no cause? I'll give everyone a few seconds there. Oh, 50-50 split. Looks like more people are saying no cause on this one. Okay, next slide, please. The answer is yes. Again, there was cause. The court found that years of secret recordings justified dismissal for cause because it destroyed trust in the employment relationship. Even though one-party recordings aren't criminal, the court found them to be underhanded, privacy invasive, and incompatible with continued employment. And the court approved the trial judge's concern that accepting this conduct would encourage routine secret recordings, which was contrary to evolving privacy values. So another interesting fact pattern there, and thanks for your participation in that one. So last one will be on the next slide. This one is about employee insubordination. It's Extreme Packaging Services in Savoy, 2025 Alberta Employment Standards case. In that case, the employee was a press operator with about 1.5 years service. The employee had been asked to correct his behavior on a number of occasions during his employment, including once for not wearing appropriate PPE. Then the employee got a written warning for yelling at a supervisor. About 1 month after that, the employee's machine was sitting idle, and a supervisor asked him if he knew what he should be doing at that time. The employee said, "Don't know, don't care." The employee was then called into a meeting with his supervisors and told his behavior was unacceptable. The employee then responded by asking for a raise. There was different versions of events given about what happened after that, and the employee was terminated for cause. The employer's evidence was that they asked the employee why he thought he deserved a raise, and his response was that if my performance is here at mid-level height, if I don't get the raise, it'll be here, and dropped his hand down. And the employer's position was that, well, if he's not going to give 100%, we're terminating your employment. The employee's evidence was that when he asked for a raise, they laughed at him and asked him about his productivity and why he deserved one. And he responded that since they didn't give 100% by having correct materials in place for him to do his job, why should he give 100%? So what are your thoughts on this one? Cause or no cause? And we'll see what the poll says. More yeses than nos on this one. And the answer was no. So the adjudicator found that more likely than not, the employee made a statement to the effect suggesting that his work quality or effort would be lowered based on that conversation that happened. The adjudicator found that just cause had not been established because the employee had never been warned prior to the final incident that his employee might be terminated, and also determined that the events were not sufficiently egregious enough on their own to warrant just cause for dismissal. It was found that the comments were made in the heat of the moment and were in the middle of a charged conversation. Obviously, I'm sure we all have feelings about that, but just wanted to show some cases to illustrate, how the courts can be somewhat unpredictable and how proving just cause can be a really high bar. So I'll turn it over to Nafisa now to talk about theft of confidential information.
Thank you, Terry. And that's actually a good segue, I think, into my section, that the courts can sometimes be a bit unpredictable on these types of issues. I guess cause and bad conduct is in the eye of the beholder, as they say. So my topic is that I'll be presenting on next is on theft of confidential information by departing employees. This issue is becoming more and more prevalent. Certainly in my practice, I'm seeing it more and more from clients. It's become very easy for clients to take off with confidential information in today's electronic world. And so what happens if that's happened to you? What do you do? And what can you do to protect against it? So next slide, please. Thank you. Protecting confidential information. An employee has duties of confidentiality that exist from various sources of law. One of them is contract, right? So in your employment contract, you can certainly have a provision, and most employment contracts do have provisions in there that expressly set out that an employee is duty bound to maintain confidentiality over an employer's confidential information, and that upon termination or for whatever reason, they have to return all confidential information. There's often intellectual property provisions in there as well. So trade secrets, know-how, those types of things, any inventions are all the property of the employer. But even if you don't have an employment contract, the duty of confidentiality can arise from other sources of law, including from the common law and the equitable law. So this is just a well-known quote from a Supreme Court of Canada decision that I've put out there for you, and it'll be in the slides. Next slide, please. So we're just going to talk today about a few recent cases dealing with theft of confidential information and what the courts did in these circumstances. And the critical thing is, if you are an employer facing this situation, that you do whatever you can and as quickly as you can to protect your property, right? Confidential information is it's like the proverbial toothpaste. Once it's out, you can't get it back in, right? So you need to move quickly and fast in order to protect your confidential information so that it doesn't end up in the public domain. So there's 4 cases in particular that are recent-ish decisions that deal with this issue, and they all deal with them in slightly different ways, because there's different ways that you can pursue your confidential information if you find that it has been stolen by a departing employee. So the first case, next slide, that I want to talk about is Bougiotis versus Mungi. At a very high level, I have a few slides on this one. I'm just going to go over the facts at a high level. So Mungi is an employee, a former employee of CleanMark. He was there for about 3 years, and he was responsible for managing 2 very significant clients. He had a written employment contract that set out very clear confidentiality provisions, and he actually reported to Ms. Bougiotis, who was a VP of Client Experience. In April of 2024, he's terminated on a without cause basis. It's an amicable separation. He's given a package. He signs off on it. He signs a release. All seems to be good. But soon thereafter, Mr. Mungi starts a campaign of harassing Ms. Bougiotis. And it's like pretty unpleasant stuff. He's constantly contacting her. It was like stalker type conduct, in the sense that he was very he claimed to profess admiration for her, wanted to keep in touch with her, talked about how he was very sad to no longer be working with her. When she tried to stop him from communicating, he used 8 different phone numbers to contact her. Eventually he's given a cease and desist letter and told stop from a lawyer that he shouldn't be doing that. He ignores that. Next slide. And in May of 2024, when he gets a cease and desist letter, his feelings or his professed admiration turned hostile. So now the 2 clients that he formerly managed start getting anonymous emails from someone saying disparaging things about the company and Ms. Bougiotis. Her colleagues start getting messages as well. So this is ongoing harassment campaign. The police get involved. Still, Mr. Mungi doesn't stop. And in August of 2024, so now a few months post-departure, the company actually goes and takes a look at their electronic systems and discovers that, lo and behold, Mr. Mungi had downloaded his entire computer drive that he had access to while he was employed, including the staff directory, confidential client information, financial information, etc. So the company immediately sues. Mr. Mungi claims, oh no, I had to take this. I was a whistleblower. And what the employer in particular brings a motion for interlocutory injunctive relief. So what is an injunction? An injunction is extraordinary relief. It's an emergency order that you seek from the court where you're asking the court to make an order requiring someone to either do something, that's called a mandatory order, or refrain from doing something. So here, the employer moved for something called, also ordinary injunctive relief, so to force him to refrain from doing stuff, but they also sought something called an Anton Pillar order. So next slide. So an Anton Pillar order, sorry, next slide. Thank you. The Anton Pillar order is an order where the courts, it's basically like a civil search warrant. So an employer, if they get that order, you usually go on a without notice basis. So you go to the court one-sided and you seek that relief, that you be permitted to go in, kind of surprise the employee at their premise and seize their electronic devices that can then be put into the hands of an independent third-party solicitor who will oversee a review of the devices to make sure that the information is taken or permanently deleted. So there's a test for an Anton Pillar order, which is set out here, and that test is 4-stage and it's extraordinary relief. So I won't get into it in the interest of time, but it's there. There's also a test for an injunctive order, so next slide please, which is a little less involved, but also still extraordinary relief. So there are 3 stages to that. The reason I put out the tests is because it's important that we be mindful of the fact that this is hard relief to get, right? So ultimately, the employer, CleanMark in this case, sought the relief, and the question that we have for you is, did the court grant the motion for the injunctive relief? So let's put that to a poll and see what you think. Yes, injunction, or no injunction? We'll see give you a second here. You can see the data. Okay, here we go. All right, so there's almost 100% yes, and the answer is yes. So thankfully here the court did agree that clearly Mr. Mungy's conduct was very inappropriate and unacceptable. Next slide, please. And the court made an order requiring Mr. Mungy to return all confidential information, to refrain from using it, as well as the Anton Pillar relief. So the court in this case insisted that the motion be brought on notice, so Mr. Mungy was able to respond to it, and he was required to turn over his computer for a 10 business day period to an independent solicitor, and which he was required to do by court order. Next case is, next slide. Theft of trade secrets. So this is a case involving Arc Compute and Anton Allen, a very recent decision. In this case, there was 2 employees who had been terminated. The first was Mr. Allen, who was a VP of sales. Mr. Allen he was terminated initially without cause, and after they terminated him, they found that he was actually actively soliciting clients, and they found that Mr. Bushel, who was the CTO of the company, was actually working with him. And Mr. Bushel was in a very senior position and had full access to Arc and AI company's software. So Mr. Bushel's employment was immediately terminated on a for-cause basis, and the employer went to court to get a return of all of their confidential information, which Mr. Bushel was otherwise refusing to return. Next slide. So in this case, the major issue was this software that this AI company was producing and creating called Nexus, and Mr. Bushel was the keeper of this software, and he was refusing to return it. So the question is, did the court grant a motion for injunctive relief? You can go to the poll, and again, we've got 100% yes, and you guys are on a roll today because the answer was yes. Next slide. In this case, again, just like the other one, the court was unimpressed by the conduct of these departing employees and immediately ordered them to immediately return all the confidential information in their possession. And there was also rules that required, under our Ontario Rules of Civil Procedure, that the court employed and looked to in order to enforce the relief. Next slide. So this is a case where there was one instance of theft. The employee, this is a Rats Chung versus BMO Nesbitt Burns. We've got an employee who'd been there for 24 years of service, and they terminated her on a without cause basis, and she sues for wrongful dismissal. In the course of the lawsuit, during her examinations for discovery, they discover that 1 year earlier, she had taken about 3 folders. She had accessed the system and had her husband actually download a USB key with that ended up containing thousands of emails that she had been collecting in order to protect herself in the context of a workplace dispute that had come up. So this all came to trial, where the court had, when the employer realized that she had taken all this, they immediately asserted after acquired cause. And so this came to trial. The judge had to decide yay or nay, was this quote unquote theft of confidential information after acquired cause. So let's put that to a poll. See, yes, cause or no cause. Give that a second. Okay, here we go. Okay, so this one's a 50-50 split. It seems like some people say yes, some people say no. The answer here was the court was of the view that no, it was not. So next slide. The court took the view that because this was one single instance, she had done it for a reason that she thought she was to protect herself, that she hadn't used the information for any reason, that she had returned it when she was demanded that it be returned. The court in that case, given all the circumstances, was satisfied that indeed this was not a grounds for cause. And then finally, the last one, I have 1 minute, 1.5 minutes left. If we can go to the next slide. This is a case where there were various thefts. And the 1 minute that I have, I'm not going to go to the poll because just in the interest of time, but what happened in this case is there was departing employees who had taken confidential information, and it was found that they indeed took confidential information, or at least one of them did. And this included things like passwords, client documents, contracts, etc., and took them over a long period of time. And ultimately, it went to a trial as to whether or not the employer sued for a return of their information and to hold these employees accountable for damages. And they had a full trial on the matter, and ultimately the court agreed that the employee had engaged in theft, and yet so the employee was liable, but the court awarded damages of $1. So it was kind of perhaps a not what the employer was hoping to get at the end of the day, but at least they walked away with a moral victory in that case. So all these cases go to show that there are, just the last slide in the few seconds that I have remaining, from a takeaway perspective, confidential information is something that constantly comes up. You want to make sure you have strong protections in your contract. Even if you don't have a contract, you still want to protect your confidential information. When an employee leaves, you want to make sure that you're taking a look to see if, especially if this is someone who had access to confidential information, and otherwise take whatever steps you can to protect it, because once it's out there, it's out there. So those are, that brings us to the end of my time. And it's been a pleasure presenting on these topics with Terry today, and we want to thank you for taking that time, and we ask that you please hit the return to agenda button at the end of your screen, at the bottom of your screen.